Good morning once again. This is Attorney Alfonso Roma, your instructor in Criminal Law Book 2 of the Revised Penal Code, and today we'll be discussing arbitrary detention. If you will be asked, what is arbitrary detention? Arbitrary detention under the law is found in Article 124 of the Revised Penal Code, and it states that any public officer or employee who, without legal grounds, detains a person shall suffer the penalty of arresto mayor in its maximum period to prisión correccional in its minimum period if the detention has not exceeded 3 days. If the detention has continued for more than 3 days but not more than 15, the penalty of prisión correccional in its medium and maximum period shall be imposed. If the detention has continued for more than 15 days but not more than 6 months, the penalty of prison mayor is imposed. And the penalty of reclusión temporal if the detention has exceeded 6 months. That's the penalty for arbitrary detention. Under the same law, it provides that the commission of a crime or violent insanity or any other ailment requiring compulsory confinement of the patient in a hospital shall be considered legal grounds for the detention of any prisoner. Now, we'll discuss arbitrary detention in relation to lawful arrest of a person. When a police officer or any private person can lawfully arrest a person without warrant, because general rule, you cannot arrest a person without warrant, or yes, that's the general rule. And what are the exceptions when you can arrest a person without warrant? The law provides, in fact, it's a provision in the rules of court that provisions on warrantless arrest, a valid warrantless arrest. Now, one of the provisions in the rules of court regarding warrantless arrest is when a person is caught in the act, is committing a crime, and is caught in the act. That's the basic, simple example that I can give you is that if you are a police officer, when you caught a person committing a crime that is caught in the act. Now again, the provisions on warrantless arrest can be found in rules of court, and it basically provides on when a person may be lawfully arrested without warrant. And this, in a simple example I have given to you, when the person is committing a crime and is caught in the act, that is when you can arrest a person. Now, going back to arbitrary detention, detention is committed by a public officer or employee. Now, if the act is committed by a private individual, then he may be liable for serious illegal detention or kidnapping. That is the crime provided for private persons. If the private persons is in conspiracy with public officer or employee, then he may be liable for arbitrary detention as conspirator. Now, remember that arbitrary detention can only be committed by public officer or employee. If the private person commits the crime of detention, he may be liable for serious illegal detention or kidnapping, as the case may be, and not for arbitrary detention. This particular provision is only applicable, once again, to public officer. Now, if you detain any person without legal grounds, you will be liable as to the crime of arbitrary detention. Now, what if you arrested a person and you arrested such person having legal ground to arrest that person, as I've given as example to you a while ago? If that person has committed a crime and you have caught him in the act, the first, I think that is the first simple example of warrantless arrest. The person is caught in the act in committing a crime. Now, say for example, the public officer or employee or police officer has detained a person because he committed a crime. Then arbitrary detention cannot be applied because you have legal ground to detain the person because he commits the crime, and the person in the arresting person or officer has legal ground to detain that person because as a fact that he committed a crime and the person arrested was caught in the act. The arbitrary detention, of course, cannot be applied because you have legal ground to detain a person. And if you have legal ground to detain a person, you have the responsibility to file the case. To file the case for that person who has just committed a crime. What if you arrested that person on Friday evening and and the crime committed is theft, or the crime committed is reclusion, no, reckless imprudence resulting to homicide? When are you going to file the case? And when will be the detention of that person be still considered lawful or justified? Now we'll direct your attention to next preceding article. That's Article 125 of the Revised Penal Code, and it's it's it provides for the punishment or penalty for delay in the delivery of detained persons to the proper judicial authorities. Now, the person arrested should be charged in court or charged in the prosecutor's office so that they will be filing the necessary case for that person arrested within, if you can tell me the exact number of hours within which the detention was still lawful, will be still lawful and legal before you can file the necessary charge for that crime committed. Now, these are the number of hours that you should file the case, because even though if the arrest was at the first instant legal, it will be unlawful, illegal, unjustified if you cannot file the charges or necessary charges of that person to the proper judicial authorities or to the prosecutor's office. If you will not or you cannot file the case for the person arrested within the number of hours provided by law, you will be liable for delaying delivery of detained person to proper judicial authorities. Article 125, delay in the delivery of detained persons to the proper judicial authorities. The penalties provided in the next preceding article, that's Article 124, shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for the crimes or offenses punishable by light penalties, and or the equivalent, and 18 hours for the crimes or offenses punishable by correctional penalties or their equivalent, and 36 hours for the crimes or offenses punishable by afflictive or capital penalties or their equivalent. In every case, the person detained shall be informed of the cause of his detention and shall be allowed, upon his request, to communicate with and confer at any time with his attorney or counsel. The reason why you have to file the charges within the period allowed by law, because if you are a police officer, you will be liable criminally for delaying delivery of a person to the proper judicial authorities. Now, again, our arbitrary detention is a detention by without legal grounds or legal reason for the detention by a public officer or employee. If the detention is committed by private individual, he could be, or that private individual could be liable for serious illegal detention or kidnapping, as the case may be, but not arbitrary detention. Arbitrary detention is applicable only, again, to public officer or employee. Now, if you have legal ground to detain a person, say for example, you caught him in the act, or in the case of bypass situation, or you just happen to caught the perpetrator of the crime, then you have the lawful ground to detain the person. But you must, as an obligation attached to it, you must deliver that person to proper judicial authorities for filing of necessary charge. If you cannot comply with the requirements of the law in delivering or filing the necessary charge against the person lawfully arrested, then you may be liable for delay in delivery of the person detained under lawful cases under Article 125 of the Revised Penal Code. Next up, we'll be discussing some provisions under crimes against the fundamental laws of the state. See you.